Hello, everyone. Thank you for joining this webinar. Presentation is hosted by the Los Angeles Housing Department, and today's topic is to discuss renter protections in the city of Los Angeles. This information is only intended for City of Los Angeles residential units. This information is not for commercial units, nor is it for properties that are outside the City of Los Angeles. This is a quick overview of what we will be covering. We will go over distinctions of city versus county of Los Angeles areas to determine jurisdiction. We'll cover residential units that are covered by the City of Los Angeles Rent Stabilization Ordinance, or RSO. The renter protections update through February 2023. Next, we'll briefly touch upon the newly enacted City of Los Angeles Just Cause Ordinance, which became effective January 27th, 2023. Next, we'll touch upon other new laws on tenant protections, and finally cover different methods that you can reach out to contact the Los Angeles Housing Department should you have any questions or concerns. Okay, this next slide covers what I mentioned earlier about distinguishing between City of LA and LA County rental units. So a very simple way to determine if you're located in the City of LA is to review your utility bills. And if you pay your water or power bill to the Los Angeles Department of Water and Power, you're located in the City of LA. Or another flag could be police services. If you reach out to your local department on there's a call and the response is by the Los Angeles Police Department, then you are located in the City of Los Angeles versus, for example, the Sheriff's Department, which could be an unincorporated area, excuse me. Now, it is important that we determine where the property is located, because there are different laws and rules that may apply depending on the location of the property, or if there's overlapping laws that could apply. Now, on the bottom of the screen, there's a property lookup website named zemas.lacity.org. In a couple of slides, we'll go over what that looks like, but that is a database that stores property profile information, and other departments read into different services that are located in the city. So if you utilize that website and populate your address and information appears, your unit is located in the City of Los Angeles. Okay, this is another great tool. How do I know if the rental property is in the City of Los Angeles? So this website, neighborhoodinfo.lacity.org, is another excellent tool to query if your address is located in the city. And if it is, a slew of information will appear as to your council district, local school district, etc. But if no information appears and you receive a message saying, quote, nothing found, then it is likely not located in the City of Los Angeles, and you may at this point want to reach out to the county, because it could be located in an unincorporated area. That contact number for the county is on the screen, so you can call toll-free number 833-223-7368, or you can reference the email address on the screen or the website for further information if that unit is not located in the City of Los Angeles. Okay, now once we determine that the property is located in the City of Los Angeles, and the next important item to identify is whether the rental property is subject to the City of Los Angeles Rent Stabilization Ordinance, or RSO. Now, under the RSO, there are additional protections like regulation of rent increases, requirements for legal reasons for eviction, which could either be at fault, tenant at fault reasons, or no fault eviction reasons. And for the no fault eviction reasons, the landlord is required to pay the tenant relocation assistance. Now, generally, our properties, these are properties that are located in the city and they were built prior to October 1st, 1978. So there'll be this instrument document named Certificate of Occupancy, and it would be issued prior to October 1st, 1978. Or if it was built after July 16th, 2007 as an Ellis replacement unit. So typically these would be units that are subject to the rent ordinance. Now, another tool, as I mentioned earlier about ZEMAs, is to use the zemas.lacity.org website, where you could enter your address, and there would be a list of accordions that will populate on the right side if your unit is subject to the rent stabilization ordinance. And if we look at the screen to the accordion labeled housing, there's a highlighted area there that says rent stabilization ordinance. And so if your unit is subject to the RSO, it would answer yes. And if it's not, then it will state no, like it does in this example on the screen. An alternative method to determine if your unit is subject to the RSO is to use our text line. You can text the words RSO to the number 855-880-7368. And then you will be prompted with some follow-up questions where you would enter your address. And then you would receive a text message letting you know if you're subject to the rent stabilization ordinance and additional information. Okay, this is the renter protections update slide. Now, I do want to preface that we had the moratorium period that was connected to the City of Los Angeles declaration of local emergency, which went into effect March 4th of 2020, and it ended on February 1st, 2023. These following rules apply to all residential units in the City of Los Angeles. So in that first header, we'll go over non-payment of rent. So given that the local emergency period ended, beginning February 1st, 2023, tenants must pay their full monthly rent in order to avoid eviction for non-payment. However, if a tenant is low income, or what is considered a household that is at or below 80% of the area median income, and this household is impacted by COVID-19 financially, then there's additional protections against eviction for non-payment that run through March 31st, 2023. And these are provisions under the LA County resolution that extend to City of LA renters. The qualifier is the household area median income, and that tenants notify landlords within 7 days of the rent due date. Now, tenants that are eligible to avail themselves of these protections will have until March 31st of 2024 to repay any of the owed rent for the months of February and March 2023 if needed. So how do you determine if a household is low income to qualify for this additional protection? And that's by looking at the screen. There's a chart here for the 2022 HUD low income limits. And depending on the number of people in your household, we'll look at the total income in the chart. And if you fall below that household, then you would be considered low income. So if you have a 3-person, for illustration, a 3-person household, that income, any income below 85,800 would qualify as 80% AMI. Okay. Now, the second header will cover the state law provisions for non-payment of rent protections. So, excuse me. There's certain requirements that had to have been met in 2020 or 2021 in order for a tenant to avail themselves of these protections. So, for the first asterisk there, if rent was owed between the period of March 1st, 2020 through August 31st, 2020, tenants could not be evicted, no eviction, so long as the tenant provided the landlord with a COVID-19 related declaration of financial distress form. And it had to be timely. So it had to be submitted to the landlord within the 15-day deadline. So if a tenant fulfilled this requirement, then the landlord could not move forward with an eviction for the owed rent during this period. Now, the second asterisk covers the second time period, where that covers September 1st, 2020 through September 30th of 2021. And the requirement there to avail yourself of this protection against eviction proceedings was to provide timely declaration of financial distress to the landlord. So that would be within the 15-day deadline to be timely, and the two-prong, and the tenant had to have paid 25% of the rent owed for this time period by September 30th, 2021. Now, this is again protections against eviction proceedings. So the tenants must still pay this rent, it's owed. However, the remedy here would be that the landlord could pursue an action in small claims court. So there would be consumer debt, and so this would then require some sort of a payment plan or some sort of settlement in small claims. But it wouldn't be an eviction proceeding, which would be to the landlord's intent to gain possession. That wouldn't be a danger that the tenant would have to deal with. So that is an overview of the state law protections for the two time periods. Now, the next header is covering COVID-19 rental debt. So tenants who are not covered by the state's declaration of financial distress that I just mentioned above, then they would continue to have city protections for unpaid COVID rental debt. And for that, there's two different time periods. So, excuse me, that covers any rent owed from March 1st, 2020 to September 30th, 2021. And that rent must be paid by August 1st, 2023. And the second tranche of deadlines that we must pay attention to is any rent owed from October 1st, 2021 through January 31st of 2023. And under the law, tenants must pay that owed rent no later than February 1st, 2024. Now, if if a tenant does need to download a copy of the declaration, there's a link here that a tenant could utilize to self-certify their income and indicate to the landlord that they're unable to pay if they qualify. Again, these protections run through March 31st, 2023, and the link is on the screen. Okay, now to provide an update on the renter protections as of February 2023, we have different headers here that I'll cover. There were protections, and they still are, in place for unauthorized pets and occupants that had to move into a unit that stemmed from a COVID impact related reason. So now through, those protections were extended through January 31st of 2024. Landlords cannot evict a residential tenant if there are still unauthorized occupants or pets that need to live in the unit due to a COVID impact. And a change in the law is that when that time comes, prior to a landlord evicting a residential tenant based on this reason, the landlord has to serve a 30-day notice to cure. And the landlord cannot serve this prior to January 31st, 2024. So in essence, that protection runs through January 31st, 2024, and then the landlord would issue a notice thereafter for a 30-day notice to cure or quit, which is important because if arrangements need to be made for these unauthorized occupants or pets, you have this time frame to work to find a solution for that. The second header, we're going to cover no fault evictions under the RSO. Now, as of February 1st, 2023, landlords can resume issuing these notices, and no fault evictions cover evictions that are a result through no fault of the tenant, which are typically landlord needs to comply with a governmental order, or the landlord is moving to evict the tenant because the owner wants to move in, or a family member or resident manager. There's demolition of unit or withdrawal of the unit from the rental market. So again, landlords may resume these as of February 1st, 2023. Now, important to note that landlords are required to submit a declaration of intent to evict with the LHD, and these are for no fault evictions. Now, another important caveat to keep in mind is that if a tenant received a notice to terminate tenancy based on a no fault prior to the local emergency period, so prior to March 4th of 2020, then the landlord must issue an additional 60-day notice. And that can't, it's already the 24th, so it couldn't happen any earlier than February 1st, 2023. So that's just, it's sort of like to revive and provide notice to the tenant about something that was put in place prior to the local emergency period. And now the landlord intends to continue with that process. So that's the additional 60-day notice requirement. And LS evictions cannot be enforced in court until April 1st, 2023. Okay, now the next statement applies only to units subject to the rent stabilization ordinance, or the RSO. Annual rent increases for these units subject to the RSO are prohibited until February 1st, 2024. Next header will cover late fees. So there was an extension of these provisions. Interest and late fees on unpaid rent is prohibited for renters that are financially impacted by COVID-19 from March 1st, 2020, so that was the beginning of the local emergency period, through January 31st of 2023. Now, the extension comes by way of the county provisions. So if a tenant meets the LA County requirements, then the late fees are prohibited until March 31st, 2023. And there's no retroactive late fees on any of the COVID-19 rental debt. Final header on this slide is to touch upon rent increases under what we call AB 1482, named the Tenant Protection Act. So this state law became effective on January 1st, 2020, and it applies to most rental units that are built between 1979 and 2007. So it's really a 15-year window, 15-year to keep in mind, anything that was built 15 years ago and prior. It also applies to corporate-owned rented single-family homes and condominiums. So if the requirements are met for the property profile in the rental unit, for these units that they're not subject to the RSO, but rather to the TPA, AB 1482, then the maximum annual rent increase is 10% for the rent increases that would go into effect between August 1st, 2022 through July 31st, 2023. Now, it's important to bear in mind that these percentages may change every year depending on the cost of living, and they will be published so that you are aware prior to the issuance of notice as a landlord, or if a tenant is concerned, they may have received an increase that exceeds the cap. But at no point can it exceed that 10%. Okay, now this next slide is covering the just cause ordinance that it's a major change in the city of LA, the passage of this ordinance, which became effective January 27th, 2023. It's important to note that this ordinance and its protections apply to all residential units in the city of Los Angeles that are not subject to the rent ordinance, the RSO, because obviously those protections we've covered earlier. This ordinance would cover a segment of units that are not covered by the rent stabilization ordinance and need to meet certain criteria of applicability. Specifically, that it applies after the expiration of an initial lease or after 6 months of continuous occupancy, whichever comes first. Now, a lot of these provisions are very much like the RSO protections, where a landlord must have legal reasons to evict a tenant subject to this just cause ordinance. Let's see. So we're broken up into at fault and no fault. Now, the at faults are just that. It is the fault of tenant's action or inaction, and that's why the landlord's moving forward with an eviction. So if we look at the left part of the grid of that slide, at fault, we have the non-payment of rent, violation of a lease clause, nuisance by tenant's actions, or if the unit's being used for an illegal reason, legal purpose. Another one is a failure of the tenant's part to renew a lease of similar or like terms, similar duration. Another one is a denial of access into the unit. So the landlord's required to issue 24-hour notice, ample notification, and tenant is not cooperating. That's a reason for eviction. That is at fault. Next one is a subtenant that's not approved by the landlord. And finally, we have a failure to comply with a THP. So this is a plan where certain improvements need to take place on the unit, and the tenant is required to comply with these and cooperate with that plan. And if there's a failure on the tenant's part, that could be a reason for an at-fault eviction. Now, on the right side of the grid, we have the no fault. So again, not the tenant's fault. It is typically owner occupancy, family move-in, or a manager. The landlord needs to install a manager, and they need that specific unit. Next, we have the demolition and withdrawal of the unit from the rental market, or a substantial remodel that requires the tenant to vacate. Next, we have maybe a citation by the governmental order, and so the landlord needs to remedy that. So that would be a no fault eviction. Next, we have converting the unit to affordable housing, or conversion of a residential hotel. And then finally, we have a HUD-owned property. So it's going to be sold, and we need to vacate the tenant for these reasons. So that would be the no-fault eviction reasons. And it's important to note that for these no-fault, the landlord will be required to pay relocation assistance and file a declaration with the housing department. Now, this grid gives an indication of what that relocation assistance amounts are from July 1st, 2022 through June 30th, 2023. Again, these are for no fault evictions. And on this grid, you'll see it broken out depending on the type of tenancy and the length of the tenancy. There's also a grid for the income. So if it's 80%, if the household qualifies for 80% AMI, there's different amounts that apply. And then you have your mom and pop, which we'll go over, that have a lesser amount. And then you have the final grid, which is the single family dwellings owned by natural persons. Okay, so the no fault evictions, like I said, are the owner occupancy governmental order type of evictions. The landlord, if they're going to choose to evict, they have to file this declaration of intent with the LAHD, with our department, for no fault evictions under just cause ordinance. Landlords may pay relocation assistance to tenants for no fault evictions. And if there are evictions from rented single family dwellings, it's important to note that we have a different amount. So if it's owned by a natural person who owns no more than 4 dwelling units and 1 single family dwelling on a separate lot, then that relocation assistance changes dramatically, and the law requires that only 1 month, 1 month's payment equivalent to rent be paid out as relocation assistance. Now, that final bullet is also an important thing to highlight, which is that landlords can deduct a tenant's unpaid rental debt from whatever the law requires the relocation assistance payment be. So this is a major change also in the law. Another big change is the notice to terminate tenancy eviction filing requirement. So effective January 27th, 2023, I stress, any written notice termination of tenancy for at fault reason has to be filed with the Los Angeles Housing Department, and it needs to be done within 3 days of service on the tenant. Now, the screen has it's highlighting where you could file these at fault notices. It's underlined housing.lacity.org/eviction-notices. Now, for no fault evictions, those must also be filed with the housing department, with the distinction that there has to also be fees that have to be paid out that are required. And again, the payment of the tenant relocation assistance in the grid that we referenced prior slide. Okay, this next slide is pursuant to this ordinance number 187737, where landlords are required to provide this renter protections notice to either tenancies that began or were renewed after January 27th, 2023. And this notice has to be posted in a common area that's accessible for all to see. This is also available on our website. Okay, next slide is covering the tenant anti-harassment ordinance, which is very important for all to be aware of, both tenants and landlords. This law became effective August 6th, 2021, and it specifically defines harassment in the ordinance with enumerated examples of what is considered harassment. So the definition is really a course of conduct by the landlord against a tenant that's targeted with the intended purpose of annoying the tenant and serves no legitimate purpose. And some bad actors will do this in order to maybe target for a constructive eviction. And so it's been codified in the law, and we are reviewing these as investigations with possible referral to city attorney for further action. And the enumerated ones you can see on the screen, they're quite lengthy. But what we're noticing and seeing is they typically stem from reduction of services, that there's no reason for it other than to annoy the tenant to leave, possibly. A refusal to do required repairs. We have entering units without reason or without proper notice. And the general thought of this is that it's really done to interfere with the quiet enjoyment of the tenant. So they're very lengthy enumerated reasons, but I encourage you to visit our website or look at this ordinance 187-109 for further information. And if you believe you're being harassed, we highly encourage you to file a complaint with our department. There's a toll line 866-557-7368. And toward the end of the slide, we'll cover other areas that you could, other methods under which you can reach out to the department. If you are being harassed, it's important that tenants keep records. Important that we keep those records by taking notes of harassing events, that you log dates, times, you get statement from neighbors, video, take pictures, because that critical evidence is going to be essential for a city attorney review and possible referral. Okay, this next slide is covering a new ordinance that will be effective March 27th, 2023, otherwise known as economic displacement. And this will apply to those tenants who receive a rent increase that's more than 10% within a 12-month calendar period, and they're unable to afford the rent increase. So if a tenant receives a notice and they're unable to pay this, then the tenant can opt for relocation assistance and to move out of their unit because they won't be able to afford this, and of course want to avoid an unlawful detainer for failure to pay rent. The relocation amount is based on the bedroom size. So in this grid, you'll see broken down by efficiency, 1 bedroom all the way through 4 bedroom. And then you have a different tier for the single family dwelling owned by natural person. So the relocation assistance, if the tenants live in a single family home, so it's important to pause there and process that. For that particular tier, the tenant has to live in a single family home. And if that's the case and the landlord is a natural person who owns no more than 4 units and a single family dwelling on a separate lot within the city of LA, then it would just be equivalent, the relocation that the tenant is invoking because they cannot afford this 10%, in excess of 10% rent increase would be equivalent to 1 month's worth of rent. And again, asterisk, that the landlord can deduct a tenant's unpaid rent from this relocation assistance amount. This is new law. It will go into effect March 27th, 2023, known as economic displacement. This again is also a new law that's effective March 27th, 2023, where landlords may evict a tenant who falls behind on rent, may not evict a tenant who falls behind on rent unless the tenant owes an amount higher than the fair market rent. So there's a threshold. And so the idea of this is to preserve housing and housing stability if a tenant doesn't owe an astronomical amount, and that protection is based on the fair market rent for the size of the unit. So for example, if a tenant rents a 1-bedroom unit and the rent for that particular tenant is $1,500, then if you look at this grid, the landlord cannot move to evict the tenant because that's, since the rent owed is less than the fair market value. So in this grid, the fair market rent for a 1-bedroom is $1,747. But since the rent owed is $1,500, then it doesn't meet that threshold, and the landlord is barred from moving forward with evicting the tenant. Okay, sorry about that. Last slide here is how to contact the LAHD. So you can submit questions 24/7 at housing.lacity.org/askhousing. If you need to report violations of the COVID-19 renter protections, you can call our hotline at 866-557-RENT or online, and on the screen you'll see that that address online. And finally, you can visit our website for the COVID-19 renter protections. Our general hotline again is 866-557-RENT, and you can reach out to the number at 213-928-9075 for future workshops. We will have a series of workshops covering different topics, and I invite you to subscribe to our newsletter to be aware of these updates, or to join our workshop, or to please call an RSVP to attend and stay informed with your rights and regulations and obligations. Thank you so much for attending. Have a great day.